Hi, everyone. James Manson here, lawyer in Toronto. I am counsel for many of the trucker defendants in the Freedom Convoy class action, which is currently pending in Ontario. Those of you following the case may be aware that a decision was reached and released this week in the case, and I just wanted to quickly touch upon that with you today. This decision was what we call a pleadings motion in the law. As you guys may know, it was argued in late January. The plaintiffs were asking the court to basically give its permission for them to amend their claim in order to add a whole bunch of new allegations and also to add a couple of new defendants. And you may have heard of Mr. Harold Jonker and Mr. Brad Howland. And so the plaintiffs were asking these two gentlemen to become new defendants in the case. There were other people as well that Mr. Champ, the plaintiff's counsel, that he was asking to be added as defendants as well. But I'm focusing on Mr. Jonker and Mr. Howland. Of course, I'm their counsel. Normally, a motion like this or a request like this from Mr. Champ, the plaintiff's counsel, is not a very controversial one. People ask for amendments all the time for their pleadings, and the court is also usually very happy to grant amendments to add new defendants. So normally this isn't a very big deal. However, in this case, we believed that it was a bigger deal, that many of the new allegations, in fact, weren't appropriate for all sorts of reasons, and that the plaintiffs shouldn't have been allowed to make them. And we also believed that in this case, it wasn't appropriate for Mr. Jonker and Mr. Howland to be added as defendants for, again, various other technical reasons. What's particularly concerning about adding these two defendants, Mr. Jonker and Mr. Howland, is that the plaintiffs want those two defendants to stand up and represent two entire classes of additional defendants, the truckers on the one hand, and all of the donors, to the Freedom Convoy on the other hand. And that's quite rare. It's very rare to have classes of defendants. It's quite common to have classes of plaintiffs in a class action lawsuit, but it's almost impossible. It almost never happens to have classes of defendants. And so the idea of using Mr. Howland and Mr. Jonker to become class defendants, as we say, raises another whole bunch of technical issues. And so we decided to challenge the preliminary request from Mr. Champ and the plaintiffs to first amend the claim, and secondly, to add these new defendants. The decision was received this week. It came out this week. I can report that we did achieve some modest success. The judge did allow most of the claim to be amended as the plaintiffs requested. And the judge did also allow Mr. Jonker and Mr. Howland to be added as defendants. And so we weren't successful on those grounds, but we were successful on certain of the new allegations. The judge did agree with us that those proposed allegations were basically inflammatory and they ought not to be permitted to be added. What I thought was interesting about the case as well, or the ruling anyway, was that the judge, in my view, really left the idea of whether or not Mr. Jonker and Mr. Howland, whether that's an appropriate way for them to be acting in this case as representative defendants. He really decided that should be dealt with at a later stage in the proceeding. The decision to me, of course, was somewhat disappointing. I had expected the judge to be a bit more sympathetic to the points that I was raising with respect to the technical arguments of all the allegations. But, that's the way it goes. Sometimes in litigation, you win some and you lose some. I think it's important for everybody to recognize in this case that this is a very preliminary step in the case. What comes next is a statement of defense. And so lawyers like me, defense lawyers now, we're going to have to basically prepare statements of defense for all of our clients. And that is really the first step to get the entire ball rolling towards the trial. The ruling this week did not decide, the issues really once and for all. So there's lots of preliminary issues still to come, lots more preliminary hearings still to come. One of the most important things is a certification motion, which is an important thing in the class action context. And that is where the plaintiffs are going to have to convince the court that the entire basis of this action is in fact appropriate, which means that the plaintiffs are going to have to ask the court to agree that it's appropriate for them to represent essentially, all of the residents of downtown Ottawa, for example. They're also going to have to convince the court that it's appropriate for Mr. Jonker and Mr. Howland to stand up for all of the truckers and all of the donors. I think that we have some very strong arguments in those veins, and we'll be, of course, raising those arguments. There's a lot left to do. We're just getting started on this class action. So your continued support of the JCCF really makes all of this possible as we lawyers continue to fight for freedom and justice here in Canada.